All right, everyone. Thank you so much for coming. Welcome to Langdale Hall, everyone. My name is Matt Christopherson. I'm a second-year student here at the law school, and thanks to HLS Beyond, we're putting on this wonderful event about the copyrightability of AI outputs. Joined with me is Christopher Babitz, the Wilmer Hale Clinical Professor of Law and the Managing Director of the Cyber Law Clinic here at the law school. We also have Rebecca Tushnet, Frank Stanton, Professor of the First Amendment here at the law school. And then we also have Jessica Silby, a professor at Boston University School of Law, and the Honorable Frank R. Tennyson Distinguished Scholar in Law. I think we have a pretty good group here.
A lot of names.
A lot of names.
And the great Matt Christopherson.
Oh, and me. This is going to be kind of a loosely moderated discussion about the copyrightability of AI outputs. There have been a lot of discussions about training and infringement when it comes to the inputs to AI models, but not so much, I think, on the copyrightability and the infringement problems of the outputs and the ownership problems thereof. So this discussion is hopefully centered around that, but since we're joined by such a brain trust, I'm going to let our distinguished guests talk about anything. So can one of our guests please just start by explaining the state of the doctrine, explain what exactly we have on the screen here, and yeah, just take it away.
Yeah, you can show also, if you'd like, the next slide I think has a copy of the copyright registration form at issue if that's of interest. I'll just say really briefly, and I'm cheating by looking at notes to make sure I get this right with the sequence of events. Stephen Thaler filed a copyright registration to register that piece of visual art, which appeared on the first slide. I think the way he describes it in the registration, which my eyes are terrible and I can't see, is 2D artwork created autonomously by a machine, and he checked a box saying it was a work for hire, but that the creative work of making that image had been done by a computer system that he had created. The Copyright Office rejected the registration. It went through a few rounds of internal review before he took the case to the United States District Court for the District of Columbia and eventually the DC Circuit, both of which agreed with the Copyright Office that said this work should not be registered for a variety of reasons we can talk about. And the precipitating event, such as it is, that I think prompted putting this on was he then sought cert from the U.S. Supreme Court, which is now denied cert. I don't know if there's more procedural nuts involved. We can go into detail on any of that, but I think that's
I just also say Thaler also tried to file a patent that was also generated entirely, but an invention that was also generated. He was testing the system, so to speak, by doing this with his lawyer, Brian Phelan. So a little bit of...
and also lost that.
And also lost that one too. Right.
So if anything, the answer that the legal system is currently giving is we don't care. We don't care about creativity, machine creativity, or machine invention, right? We just have a threshold, which is the human has to be doing it,
right.
Or at least has to be doing something,
right.
In order for there to be something copyrightable. Just like we don't care if a dog can paint, or actually an elephant. Elephants have been known to paint.
Right. I mean, if you think back to the earliest days of copyright in the United States, 1790, the idea was that copyright was supposed to promote the progress of science. That was the constitutional mandate. Science then meant learning. It actually meant promote the production and dissemination of knowledge. And the only scope of copyright were maps, charts, like navigational charts, and books. So the scope of copyright was actually quite narrow for a very long time until it gathered steam in the 19th century. But it was always supposed to only incentivize people who care about law, theoretically humans are supposed to, and not animals, not nature either. We've had cases where people try to protect a garden, for example, and the idea is that the beauty and the aesthetic beauty from that comes from nature, and law doesn't incentivize the growing of or the way flowers grow. So it's only supposed to affect human behavior, and that's why humans matter and not machines.
So I also do think that, as Jessica's written about, part of why we're here fighting about this is the technical debt, essentially, of the copyright system, which is accumulated by accepting ever more products of machines of machine-human combos without really requiring the human to do much, ultimately. So when we started protecting photographs, it was in a context where the photographer, so first of all, at that time, photography took a while. So like you couldn't photograph a person who was unwilling to be photographed because they could just wiggle. And in that case, the Supreme Court said that the photographer who posed the subject, decided what they were going to wear, put them in, a setting that person was the, creative mastermind, and therefore owned a copyright in that photo. That did not entail that every photo that you snap with your phone is copyrightable, but that's the result that we're at right now. But because we decided to stop thinking about what level of human-machine interaction leaves the human in charge enough to deserve a copyright, that's why we're struggling now.
Right.
And having done that for photographs and being willing to give copyright in security camera footage, it actually turns out to be very difficult to say why, unless you out and out say, like, I did nothing. Like Thaler does.
Right, that Thaler was pushing the button by just saying, admitting he had no control over the output. I mean, we still do litigate photographs, actually. I mean, there are a bunch of lawsuits about like real estate photos and security camera photos and stuff about trying to figure out where the human's input was in the outcome. And what you own when you own a photograph is what you added and what you can point to what you added. And so when we litigate two photos that are quite similar to one another, we have to argue about sort of what the human behind the camera did that can be owned other than the human face or the architectural work.
But we don't generally say the security camera footage. It's usually copied because there's an interesting thing showing up on the security camera footage, and that can't be replicated. That's not that's a question of, is it protectable in the first
place?
And by not having bothered with the answer to that, we've set ourselves up.
Right.
So with all of these questions about how you pose the subject of the photograph or where the light sits or whatever it is, make me think of the obvious analogy to prompt from the AI context, and I'm kind of tempted to suggest we go to the last slide, which is
let's talk about this one first, though. So Zarya of the Dawn, this is an interesting way where artists many artists or authors will embrace the machine to help them do their work. And so the author of this graphic novel wrote all the text, but was not herself a visual artist, and so wanted to put a graphic novel together and use the machine as a partner. And prompted and created all of these images, and then tried to register the compilation of the images and the text. And what the Copyright Office says is she can only get the selection and arrangement of the outputs. She can't own the images themselves. She can own all her text, and she can own the text in relation to images, but the images alone she did not generate, and so she cannot own. And so one of the things about copyright is you can create a database, for example, that is based on public domain information, and if you select and arrange and coordinate the information in a way that's original to you, you can own that selection and arrangement coordination, but you can't own the underlying information that otherwise would be in the public domain. And so that's the analogy in the Zarya of the Dawn case. So this is an example where the artist wants the copyright, is using the machine in a productive way rather than in some other way.
The other just sort of factually interesting thing about this is, as I understand it, the initial registration itself was not very clear about what had been done with AI and what hadn't, and then she went online and wrote about what she had done, which brought it to the attention of the Copyright Office and caused them to go back and revisit the registration they had previously issued, which is interesting. Right. Unlike Thaler, who checked the box and wrote.
Right. So now the Copyright Office now requires, after the past couple of years, that if you're going to file a registration of a work that is indebted to generative AI, you need to disclaim any part of the work that was made by a generative AI system. So in the same way that if you file for a translation of a book, you're the translator, but you didn't write the underlying book, and it was a lawfully made translation, you can own your translation, but you're going to disclaim the underlying work on which it was based, and that's how Copyright Office apportions ownership between underlying works and new works.
And it's probably worth interjecting here two salient points. First, registration is not required. Right? So their works are created, they're copyrighted upon creation, and so you don't have to tell anyone. You only need to register if you want to. If you're a U.S. If you're making a U.S. work, you have to register before you sue, and everyone has to register if they want statutory damages and attorney's fees. So there's a strong reason to do it, but there's no screening point that is absolutely necessary. So you can just go and you can send takedown notices to people based on AI generated works, and they'll have to decide what to do about that. And the other thing, the point I want to make is you don't have to tell the Copyright Office exactly what you did. You just have to say, there's some AI in here. And so in terms of what useful information that will give people, the answer is not much. And in Jessica's example, you could tell the difference between the data in the database and the database structure, right? Or in a translation, you can tell the difference between the book in the original language and the translation. With these disclaimers, you probably will not be able to tell which parts are actually protected by copyright and which aren't.
Right, so this Copyright Office actually says if you've used more than a de minimis amount of generative AI content, so they have this threshold. But I think that the Copyright Office, if you admit to using generative AI, I'm going to predict, although maybe not in the current circumstances when they are so understaffed, but in the future there will be asking more detail about disclaiming.
This is also a very maybe obvious point, but I want to pick up on something Rebecca just said, which is that unlike the example of a translation where my translation, I disclaim the underlying work may itself be subject to a copyright. In this case, the import of a finding that the computer can't own it because it's not a human creator, and I can't own it as the employer for hire of the computer, see Thaler, is that the copyrighted content is actually in the public domain. Right? So there is no copyright. I think in the image on the
there's no copyright in those underlying images at all.
Now, is progress served by this approach?
Yeah. Progress usually just means more accumulation. I mean, if that's what it's typically meant. Science means learning. It tends to, but the copyright law over time has tried not to judge what that means. One person's, what is this?
One person's lyric is another man's obscenity.
Yeah, right. We try not to discriminate against forms of art and science, but there's a point at which the accumulation probably becomes prohibitive of everyone else enjoying the learning. To where that line is, I'm not sure.
Now, in a recent amicus brief in the Thaler petition for cert, Professor Larry Lessig was one of the amici. It was this brief from quite a few IP professors who said that this arrangement of the Copyright Office saying that AI-generated works generally don't produce a copyright is deleterious to progress, to the economy. It was a very doom and gloom brief. What's your response to that?
Well, I've never thought we need copyright to produce art and science. I mean, we had a lot of it before 1790, and we will have a lot. Most people don't exercise their copyright. You're all copyright officers. I wrote a whole book on this, two of them, in fact, right? So I'm not worried that shrinking copyright or failing to expand it is actually going to retard the progress of science. Not at all. In fact, I think there's good empirical evidence that it won't. Right?
Yeah, I would just say, this goes to Matt's earlier question about what is progress served, right? The balance, again, to state the obvious, is that some protection incentivizes me to create things because, which is the silly example, if I wake up and decide, am I going to make something today, and I open my Copyright Act and say, oh, I'm going to have X number of years of protection, and then I suddenly feel very incentivized to write a symphony or a novel or something. That's not how people create, as Jessica points out. The flip side is that if I'm going to create things, it is helpful and beneficial for me and probably helps the progress of science and the arts. If I have a corpus of things that I can draw upon, like the great public domain works of William Shakespeare, et cetera, et cetera, et cetera. So striking that balance between some level of protection, which again gives me that incentive, and a corpus of public domain works on which I can draw, is kind of the name of the game here. And I think I come out where Jessica comes out, which is I worry a lot about a world where we have so much AI-generated content just constantly coming out of these machines. If all of that is subject to robust copyright protection for the full term of copyright we have in the US and around the world under the various conventions, that's an awful lot that's locked down by copyright. And I worry that that might actually impede.
We don't need more copyright.
Right, and I'm probably on the doomer side as well, but I will say, like, 20 years ago, there was already much more stuff than you could ever read in your language, directed at you, like this, you know, that overwhelmingness, like that fire hose was on when Facebook turned on. And so it's not as if, like, more stuff you're never going to look at is going to make things, you know, completely different. That being said, I do think one of the interesting ways to look at the Copyright Office is the anti-prompt. So one thing that they're pretty clear on is if you just prompt and you don't then do your own work in some way, like, you know, moving stuff around, then you're not going to get a copyright. That's a labor policy, right? What the message was, and I think the studios have really gotten it, is we're not going to let you replace human beings with machines all the way down. If you do that, then you will not have something that you can have as your franchise tentpole. Regardless of whether the public will accept it, you won't have a copyright in it, so you won't make it. Because those are copyright-motivated industries,
Right,
or at least
right.
they're money-motivated
Yeah.
industries, and copyright is the way that they make their money.
Right.
And so regardless of its theoretical consistency, of which there's not much in copyright anyway, I think it strikes me as a perfectly reasonable labor policy to say, yeah, no copyright and stuff that's just a result.
Right, just the result of prompts.
It also could be, and I have not talked to Professor Lissig about this or about that brief, but it also could be that there are other contexts where there's plenty of doom and gloom to go around in AI, where we want the prompter to have some responsibility for the actions of its agent, its sort of pseudo-employee. And so, you know, again, it may be that work for hire and in the copyright context doesn't make sense, but it might well make sense that if I direct the AI to do something that causes you some sort of tort harm, I probably ought to be on the hook for that. And it may be that that's what's driving some of this involvement.
I mean, I can imagine the idea that AI is going to, if you ask questions of the copyright system to produce more distributive justice or more equality among artists, one of the things you want from a copyright system in this moment is that the benefits of copyright distribute more equitably. One could imagine thinking small people using AI might produce things that can compete with the big studios, for example, the big labels. And in that way, I want those people to be able to use those machines to basically to shift the political economy of the copyright industries. So this is where I just feel like, again, this is not a copyright problem. This is it could be a monopoly problem, it's an anti-competitive problem, it could be, there's all sorts of things that we could think about fixing in our labor markets and in our industries, but putting all that work on copyright feels like, in the end, when what we have are chips or assets, the people who can accumulate the most and harness them are the ones who win that game, and those are rarely the little people who are going to use the machines in the beginning to benefit themselves. It's never worked out that way historically, and so I'm not sure why it would work out that way this time.
Well, can we go to the single slice of American cheese, single piece of American cheese? From my understanding, if I remember correctly, this was rewarded with copyright. Am I correct in that?
Yes.
So what makes this?
So there's a video. The artist submitted a video of the interventions that they made on the piece to make it look different than the initial output. And the Copyright Office thought that was sufficient evidence of human involvement in the ultimate appearance of the image.
Right. So this was just an amazing lawyering moment, I feel like, where where the Copyright Office did want to reject the image.
Mhm.
And then what the claim of the registrants did was submit video evidence of how they in-painted the result of the output. And so by giving the Copyright Office more evidence of what the human did by adding things, and it's about a 12-minute video of this is what I added, this is what I moved, and it basically became a selection and arrangement and coordination output based on demonstrative evidence of the registrant of what they added to the machine output. And this has been sort of touted as a win for digital artists. But for me, it's an example of what the Copyright Office, I think, might be starting to care more about, is we want more evidence of what you're claiming. And it's never been, to Rebecca's point, that when you file for copyright, that you have to claim or disclaim with the specificity that we do with patents, for example, or even with trademarks, for example. And so if that's where we're moving in the copyright space, that's pretty interesting from the perspective of practice and scope of copyright, which has often been very difficult to determine.
Can you go back to the cat picture? Because just to kind of build on that, I think that the thing that was on the screen a second ago, so this example comes from one of 3 reports the Copyright Office, the U.S. Copyright Office has put out so far about the state of AI and copyright. And this example goes to show that if you enter that specific prompt and get that particular picture, the Copyright Office is going to say that's not registrable. And one of the reasons is they say that if you enter that prompt multiple times, you might get different pictures. I think the point that Jessica just made is that if you can provide a lot of evidence that it wasn't simply I entered a prompt and I got the result, it was I entered the prompt, I got the result, and then I massaged it and changed it and added a lot of additional expression, they're going to reward at least that additional expression over what the computer can.
Which may be all you need.
Yep.
What you're trying to do is license, for example, that particular copy.
So at HLS Beyond, we care about informing future attorneys, of course. And so is this what us future attorneys have to counsel our artist clients about? Like, you have to video yourself making this object and massaging it through AI prompts, and just to make sure that you have that evidentiary backing. And on the flip side, if you're defending against infringement, are you going to say, show me the money, show me where you were massaging the AI prompt into making your final image? And if you don't have that, who knows?
Absolutely. So I think the answer is litigating cases is going to become more expensive when the question is not one of pure copying. So pure copying, right? All you need is that little bit, and then now there's an infringement, and we can fight about other things like who's responsible and whether it was fair use. But a very thin copyright is still a copyright. But if it's a question of substantial similarity, which is for non-identical copying, then yes, a defendant is going to say, show me what here was created by AI, and anything that I copied that was created by AI is not actionable copying.
So I was asked this question recently at a different event, and it used to be more of a practice for artists and scientists still do this. They keep notebooks about their creative journey. Musicians do it a lot, for sure. Creation tapes. And I just don't think that I would advise all of my clients to do that. That's the way lawyers draft affidavits based on those things. And I think many artists who have a daily practice of producing things do that anyway at some level. Like, that is part of the way they ideate. So I'm not so worried about this being burdensome on practicing artists. Leaving an evidentiary trail can sometimes be also difficult. But we argue about that in discovery.
As you're saying that, I'm thinking about creation tapes for musicians and video recordings of folks in the art studio. Mm-hmm. I'm juxtaposing that with software developers and this notion of we're going to white room, we're going to block ourselves out from anything on the outside. And I'm thinking out loud about how that's going to interact with the very in-depth back and forth relationship that software developers have with AI tools themselves now to kind of build software.
Well, there's just all sorts of surveillance. You can just have a camera going.
Well, I'm looking at this prompt. You could ask that prompt to an employee that you have who has signed a valid work for hire agreement, and they could come out with a completely different, picture of a cat without your input in the same way. Obfuscating from the labor concerns, which I guess are very relevant, Why isn't that the right thing to do here? If it's agentic AI, it's agentic. You're an agent.
It's not a people.
Yeah, we don't.
Again, I can hand bunch of cans of paint to an elephant and I'll get something. Or, there are rock formations that look like faces, right? Pareidolia, we're really good at recognizing stuff, patterns and stuff. But
Yeah, I'm just not sure what problem it's solving to
Yeah.
give it copyright. So, I mean, part of it is you feel like there's some sort of unfairness, and well, one thing gets copyright and the other one doesn't. But I'm like, so what? But so what? So what problem is it actually solving?
well, I mean, there is an epistemological problem. You used to be able to be confident that something that looked like a photograph
Yes.
or a picture had an author, right? And the elephant paintings were the really rare case, and they all looked like bad Jasper Johns anyway, right? Like they weren't representational. And now you can find representational images without authors, I think, are really the sort. Like, it's interesting. We haven't had too much angsting over AI written books. Like, they're terrible, right? They're slobs.
I angst of them all the time.
Okay, they have less reach because maybe because people don't.
They crowd out.
Do
I mean,
they?
the paper mills. The story about the paper mills and the publishing companies are really bad. Yeah. And in the fan world, they are really hurting a lot of fan communities as well. But again, that's not the epistemological or the aesthetic is not a copyright problem necessarily. Like, we might ask ourselves hard questions about, do we want our world full of stuff that impersonates a human mind but is not produced by a human mind? Copyright is not going to solve that problem, that mysterious philosophical problem. We can either grant it all copyright or not grant it all copyright. It still may be produced, and it's still mysterious about it, but that's just not. That's a different. There's a fraud question. There's a disclosure question. Like, do we want all these things labeled? That's a different. Maybe that's something you all want to talk about, but I don't feel like giving it copyright or not giving it copyright answers the interesting questions that are about whether we care about a human mind behind the work.
Well, I guess so. I don't know that I agree with what I'm about to say, but since I don't want us to all just agree with each other all the time. But I mean, Matt's original question is sort of, what if I gave that exact prompt to a human creator as a work for hire, and I'm a corporation, and so I own it as a work for hire, and what is really the difference between giving it to an AI and to a human being? And the answer was, it's not a human, and I'm not sure that quite gets us where we need to go. If we're talking about a kind of work that ultimately has a corporate owner anyway, what difference do we care?
Right. Are corporations people too? That's the question.
That's not the question.
And the answer, no, it's not the question.
Well, I don't know. I guess
the corporation has directed an agent to do this because they want it. It's going to benefit their business.
Right.
There's some sort of socio-economic relationship between the agent, the corporation, and the person that we might care about, that has contracts maybe, or has there's a whole sort of ecosystem or institution around it that we might be protecting for other reasons, right? I mean, the United States is one of the only, now I say this and I'm questioning myself, most copyright jurisdictions do not grant copyrights directly to corporations around the world. The United States is one of the few. So corporations can be authors, actually, the way humans can be authors. Most other jurisdictions, am I right?
Yes. Oh, yes.
It has to be a human that transfers the copyright to the corporation as a holding agent. So you might ask the bigger question as, why do corporations get to do that in the United States? That is, again, not a copyright problem. I mean, copyright exacerbates it, I will say, but it's not a copyright problem.
Now, also talking geopolitically, though, some other nations have gone the other way from how the U.S. Copyright Office has done. Japan, China, they have flirted with the idea of actually providing valid copyright to authors who prompt an AI model to make an output. In terms of just raw comedy or parody, should we kind of go along with the trend, or should we buck it?
I mean, what would we get? Right, out of doing that. So our obligations are to grant copyright to foreign authors on the same terms that we grant it to people in the U.S. So sort of in terms of reciprocity, we're already entitled to reciprocity. So we don't need and other countries do this too, right? So because they look at the work for hire and they're like, what the heck is this?
Right.
right? And they sort of integrated it into their system, but that can be done without actually changing your own rules, it turns out.
Yeah. So I don't know if this is why other countries are doing this, but I will hypothesize that they're trying to build their own industries and compete with the United States. That maybe that using the AI system and not wanting to diminish the copyright in those AI outputs in Japan or whatever is an attempt to basically level the playing field globally with regard to the industries that are maybe, whether it's software copyright or it's visual images and video game copyright, for example. I imagine that. I just thought of the Vetter case, which actually screws a lot of that up. But
Yes.
Yeah.
That is a copyright problem.
That is a copyright problem.
Fifth Circuit.
Yeah.
Fifth Circuited.
Fifth Circuit, and there we go. Right. Yeah, but it's not about AI. We should get questions though.
Yes.
Yeah, let's do it. Anyone wants to raise a question? Yes, please.
I have a bit struggle to understand what is the commercial. Sorry, I'm a bit struggle to understand what is the commercial implication to allow the person to have only the copyright of the prompt, but it's not granting him the ownership of the entire photo that was generated by the AI. So. Can he still claim the 100% of the economic return of the commercialization of that picture? And because if he has a copyright of the prompt, that prompt can generate different outcome as different AI model. So can he also claim the partial copyright to the pictures generated by different models?
I don't think so.
No.
No, I think the idea is that the image that results, or the song, or whatever creative work results from this, is not owned by the prompter, and it's not owned by anybody. It's in the public domain.
Right, so you can own a prompt the way you can own a haiku, like some collection of words. You can prevent other people, if you you try to prevent other people from using that string of words, copying them and stuff like that. That's a very unusual situation, I think. But the relationship between the prompt and the output, the Copyright Office has said, is broken. Because one prompt doesn't produce one specific outcome, the same one all the time, the outcome is free. The outcome is owned by nobody. If you're asking if you then in Paint, you get an outcome, so you can own the prompt separately from the output. Let's just talk about the output. If all you want is to control the output, or own the output, what you have to do is add stuff to it to own it. And then your question about economic significance is important because it's possible that if you in Paint and you make changes and somebody copies the exact thing, you get a copyright infringement. Like, just because they copied only a little bit of it doesn't mean that they haven't infringed your work as long as you own it. The economic significance could be the same if you register. Now, damages is a completely different thing in copyright law, but there's a lot of lawsuits and cease and desist letters or whatever that get you several thousands of dollars just because, even with very, very thin copyright. So the economic significance may not actually be that great.
I've been thinking about the damages question. I do wonder if I have a work that I created jointly with AI and I did the in-painting, I added my own content to it. And then in discovery in the case, as we said, there's going to be all kinds of questions. Do I have a recording of me doing it? And what percentage is the AI? What percentage is me? But at the end of the day, if $1 million in damages were done, are we going to apportion that and say, but Chris only contributed to 11% of that and 89% of it was AI and that's public domain? I'm guessing that's where this goes.
Right, the jury is supposed to.
Yeah. So these cases never go to a jury, though. I've been involved in a couple of cases recently about that, and insurance companies are behind a lot of the settlements. And so there will be, I think there's going to be a whole new insurance market on infringement things that are going to create caps and different kinds of weird incentives. So I have seen like a range of $15,000 to $75,000 settlement ranges for very thin copyrights under situations like that. So the economic situation, I mean, you're right to ask that question. For people who are just looking to license or make money, basically turn their copyrights into some dollar signs, I'm not sure it matters.
Sorry. Thank you.
Thanks for the very interesting conversation. I'm curious, you started off by discussing the tracing the development of the doctrine and use the term technological debt, and I'm curious with the example of the single piece of cheese and the Copyright Office seemingly taking a more granular approach to interpreting the level of human interaction. If let's just say that's the direction the department is headed in now, do you think that that's responsive to concerns about technological debt, or do you think that it actually exacerbates it by maybe further expanding the penumbra of protection? I'm curious to hear your thoughts.
It's responsive, but it won't help unless we go back and say, okay, now do photography, right? Now do security cameras, right? So let's have a conversation about what one scholar called whether you need to put more than a penny in the turnstile. Now completely dead metaphor, I guess.
Both pennies and turns.
Both pennies and turnstiles seem to be going, I guess the turnstiles are
That's
fine.
true.
But that, it is fair to say that it's wrong to treat AI as a uniquely different tool. There are clear continuities with existing tools, but and so I think it would actually be productive if we said, okay, having now seen where we've landed with AI, here's how we're going to think about photography. Here's how we're going to think about video. Here's how we're going to think about, found art and gardens, right? Just make it so that you don't have to invent a new theory if a new technology develops.
I just also want to say, I mean, that sounds like a lot of work, and it sounds like a lot of industries are going to resist that because they like collecting copyrights very easily. I think there's a smaller hurdle one can imagine baby steps in claiming in copyright that would really do a lot of good in a lot of industries. And so I wouldn't close the door because we have to go back and redo everything. I would say let's do a little bit more disclaiming or claiming at the registration stage just for clarity's sake. I think we're still going to get a lot of pushback on that, to be honest, but we'll see.
Great.
Thank you. Thank you. My question relates to something, Professor, you said about how the prompt is like separate from the output and that it's just could be a multitude of ones. So I'm going to caveat this question with I haven't taken copyright yet, but how does this discussion relate to derivative works if someone were to like upload something they created into an AI model and then they enter some prompt with it and there's an output? Is after Thaler, there's no human authorship errors at public domain?
No. Oh, right. So that's a great question. And the copyright, I have the part 2 of the copyrightability, the Copyright Office's explanation. They have that exact example where, so you can upload your own drawing. Let me make sure I understand I can give the system my drawing, and then out will come a new version of the drawing. Oh, this is the example they give. I don't know if people can see that. It's not, so it's this little sort of black drawing right there, and that was fed to the system. And then it said, add some roses, or put a great, what is that? A young cyborg woman, roses, flowers coming out of her head, photorealism, cinematic lighting, hyperrealism, hyper detailed, whatever that means, right? And the output was this. So what the Copyright Office said is, you clearly get to keep what you owned that you added, and now I can't remember what it.
Well, they said, it'd be so to the extent it's reflected in the output, right? You just still own that.
Yes,
Right? There's no new derivative.
There's no new derivative work. The drawing itself is a copyrightable work, and its expressive elements are clearly perceptible in the output, including the outline of the mask, etc. But appearing in the final, the applicant disclaimed any non-human expression appearing in the final work, such as a realistic three-dimensional representation of nose, lips, and rosebuds, as well as lighting, shadows, and background. So after reviewing the information provided, the office registered the work with the annotation stating, registration limited to the unaltered human pictorial authorship that is clearly perceptible in the deposit and separable from the non-human expression that's excluded from the claim.
So basically, you start with one copyright and you end with one
copyright, yeah. So you don't lose your copyright by feeding it to a system, is the short story, yeah.
But don't feed your stuff to the system.
Roger.
Well, thank you very much. I'm wondering, the Copyright Office, how are they drawing the line between the selection and coordination of the outputs, or when they are going to grant, oh, you own this work? Like, I don't know, what is a single piece of American cheese? Is that the whole work?
That's the whole work. So I think the doctrinal answer is every work has unprotectable elements, right? It's for every work, there's something you can say, whether it's the idea, the themes,
Sends up there.
right? So this is another closer, more granular level of that, is what I think.
And you might wonder, so that's different from a patent. Well, it's not always, but so a patent will have claims, the trademark will have classifications and sort of, and will have gone through a registration process. We only really know the scope of a copyright claim when you litigate it, to be honest, when you have something, you compare it with something else. So they are registering this as a form of insurance policy and as a game. They're playing with the Copyright Office, which is fine. And then somebody else is going to maybe make something similar in the world, and they are going to, then we're going to have a dispute that compares the two. And it's that when we start talking about, did they copy that which I claim I own? That's the only time we care about scope, if it's not an exact copy.
I do wonder if that suggests that we could move more toward a patent-like system for review of copyright applications that requires a lot more scrutiny, that requires a lot more disclosure, because in general, the copyright registration system is pretty hands-off, and exactly the Copyright Office more or less stamps the things it gets, and then these issues get sorted out at the time of regulation, of litigation, rather. So.
Thank you, guys. I'm going to use the same caveat earlier. I have not answered the copyrights. This might be misplaced. But I'm kind of wondering, in the context of patents given to AI massage works, how substantial similarities can work. Like, say, take for example, you work using a particular model, massage it, and you're granted copyright, and then someone else using the same model works and develops it either unknowingly, maybe their prompts are similar, or maybe their prompts are completely different. And then the AI, maybe because it's similar model trained on some data or whatever reason, creates a similar output. How are we going to approach that?
Yeah, so this is nobody really knows yet. You did the thing which lots and lots of people do when they haven't taken copyright. It is copyright, not patent. Right? Patents for inventions, but and copyright is for expression. But anyway, the problem is copyright does have a copying requirement. So. My favorite example of this is there's this photo that won this photography competition. It was a beautiful view of an iceberg, and somebody else showed up and was like, "That's my photo," and showed, they had a photo that looked exactly like that. And eventually, forensic examination reveals these people are standing beside each other, right? So that they took the same photo. There is no copyright infringement because neither one copied the other, even though the photos look almost exactly the same. Now, the difficulty then comes is, if they were using the same model, there's definitely no intent to copy, but the black letter law, possibly wrong, is that you don't need to know that you're copying to copy. So it is possible. So I think what the plaintiff would say is, my work was, my output was ingested into the model, because that's what they do, and so it must have been part of the prompting space for the next one. I think we're going to have to take that on its own terms and say, okay, what parts, did something owned by the plaintiff get copied by the defendant? And it's going to be very difficult.
I just want to, just because you hadn't taken copyright and there are other people in the room, so independent creation is a very important doctrine in copyright law, and it is a full defense to infringement. If you made the work independent of the other work, and you just came up with the same poem, you came up with the same song, and you did not have access to the one that, you were allowed to be an author too of the exact same thing. Copyright is deeply democratic that way, and it likes that. The problem that Rebecca was just talking about in terms of, she says, without intent, there's a thing called subconscious copying, So you might not know that you're writing a song that sounds exactly like a song you loved when you were 14, but it turns out now you're 35 and you're a songwriter, like the song sounds a lot like your favorite song, but it was in your unconscious. That is still copyright infringement under our probably stupid doctrine that we wish didn't exist. The question then becomes with machines, when the machine is like a brain and has ingested all the songs and ingested your, is it subconsciously copying from you because of the way the machine was trained? That's this new version of the problem that we don't know. Do we blame the machine? Do we blame the person who prompted the machine? Those kind of chains and causation, which everyone who knows about torts worries about. That's the newest version of this problem.
But even if we blame the machine, we will still have to figure out if the machine did something infringing.
Yes. We will still have to, and as we were talking about before, even the people who created the machines don't know how the machines work.
I suppose the good news is that they put in their licenses whenever you make stuff, like we license it back for training. So
Right.
Too bad.
Well, and I just want to say one other thing, which is that courts already in doing substantial similarity analysis look not just at whether so let's assume there is copying, no independent creation, let's assume there is substantial similarity, it can't be substantial similarity as to sort of unprotectable elements, right? So if the reason why, if I listen to Rebecca's song, I quote unquote copy it, but the thing I've copied is the fact that they both use a 1-4-5 chord progression, which is a very standard musical chord progression, that's probably not going to rise to the level of infringement. So there is this backstop in all of this with, if the reason why our mystery novels are similar is because they use the same tropes of mystery novels that all mystery novels use, that's not going to be action.
That's right.
And courts do this already.
Right, but the epistemology, the how do you know part is going to get a lot
Very
harder.
different, yep.
So the originality and authorship doctrine in copyright right now seems to be a primarily aesthetic exercise where courts in the business of, trying to assign artistic merit and creativity to a certain creator. And cases like Feist have sort of disavowed more utilitarian economical takes, rejecting like a sweat of brow theory, for example. But a lot of the AI discourse has traditionally so far sounded in economic and utilitarian terms, where people are worried about things like market dilution, and the doctrine, the enforcement comes out in like fair use and some of the more utilitarian and economic aspects of copyright doctrine. I'm curious if in the originality and creation and in the authorship space of the doctrine, is there a way for the utilitarian and economic concerns to manifest, or are we going to see sort of a separation in which parts of the doctrine handles, the utilitarian and economic concerns posed by AI?
So I guess I would push back a little bit on that characterization. So it's true that Feist says there has to be a creative spark, right? And that's just the sort of basic, there has to be a human there doing something that we recognize as creative and not as mechanical and not as copied from someone else. But once that happens, we are profoundly interested in utilitarian concerns. And so I think maybe the answer is copyright as a field is about that human spark. And then if it's about something else, we have other regimes, like we have patent, right? Or, we have trademark. If what you're doing in the world is not, putting in your creative spark, then we'll regulate it in some other way. So, but once we've decided we're in copyright land, utilitarianism matters a lot to our concerns, as do varieties of moral rights, right? Clearly, especially in lay understanding, like there's a lot of moral weight to being an artist, and even in the law, moral rights concerns end up showing up one way or the other. But that means that you're going to have a question of who is entitled to moral consideration, and it does appear to be harder for people to say the machine is.
I just also want to say the originality doctrine sounds like it's about aesthetics. It's about origins. It's about the origin of the work as a human. It's not about the expressive elements of it per se in an aesthetic way. It's about that the expression came from a human. And so that's an easy thing to confuse.
Like a case book is fully expressive, even though it's
Right.
just a whole bunch of stuff we hope is useful.
Right, so originality really does mean it has its origins in a person. And the assumption is that people have some creativity. That's the fiction. I mean, maybe it's not fiction, sorry. But I just, the economic issues are all over the defenses. I just want, the defenses of copyright are just full of these questions about trying to balance market benefits, market harms, which fields are going to get benefits. Like the libraries have a whole section to it because they're supposed to be nonprofits, and so we care a lot about about economic systems in copyright quite a bit.
Great, we have time for one more question. I will say that a lot of people here have so far said that they have not yet taken copyright. I would very much recommend it.
Hi, this has been great. I also taking copyright. My question is around, like, a lot of the examples, this was so interesting, a lot of the examples were these very clear cases where, you know, like the model's over here and the creative work is over here and they put it into the model and then, you know, this is what goes into the model, this is what comes out of the model. But as we know, the creative tools are more and more incorporating AI so that there isn't this transition that you could even document. And what seems to us natively or intuitively like AI to the next generation will just seem maybe like it's coming from them because, you know, it's like your line gets finished, etc. So is copyright law conversations anticipating when there's less sort of brittleness in the process and it's harder to detect? Because again, if Adobe is successful, right, and the music generating tools are successful, then it might feel like one's full creation when in fact there's a lot of AI.
Yes, cyber. I'm so glad you asked that question, Newman, because I was actually going to ask you, Rebecca, this question afterwards, because I reviewed a contract yesterday from a modeling agency that was trying to distinguish between the kind of AI use that is acceptable to the subject of the models. The model was looking at this, basically asked me to look at it, and the company is now trying to figure out, like, we use AI to Photoshop all the time. We've always done that. But a lot of models and like actors and et cetera are trying to disclaim, they're trying to basically prevent their hiring partners from using AI on them in biometrics and stuff like that. So this is a contract that was trying to distinguish between the kind of AI that we are going to accept that we've always used and the kind of AI that we know you as a model do not like. And so what I think we might be seeing is we're going to start seeing practice-driven specificity. So in different fields, in music, in video games, in movies, the industries are going to start deciding before the law does what kind of AI use we are going to say is creative and is acceptable and what was not. That is my best answer to that question. It's a great question, but I started freaking out when I saw that contract because I'd never seen a contract like that before. And the language of trying to parse those two things together felt very slippery and very not in the model's favor, for example. But trying to figure out how we could negotiate that contract was hard because obviously they should be able to use Photoshop, like obviously they should do that, but what kind of alterations to that person's body with AI was not going to be okay? Like, what are the words we use? What are the distinctions we make? That was hard.
So I find that a good answer, even though it's not actually much of an answer.
No, it's not. No.
But it strikes me as quite true. I've actually noticed this a bunch. So a bunch of the laws that have already been passed, including at the state level, about like digital alterations, I keep saying to people, you know that you've now outlawed Photoshop, right?
Yes, right.
You know that, right?
Yeah.
No, they don't know that.
Grammarly, right?
You know, right? You know,
Autocorrect.
right? Yeah, right. No, they know what they mean, which is a consistent challenge of law, especially a common law country like the U.S., is to translate everybody knows what we mean to something that can be written down and interpreted 20 years from now when they know something different. And so I would say I don't have a great answer. I do know it is a problem that people have not yet acknowledged. And so in the civil law countries, they can actually say, look, you know what we mean, right? Nobody meant Photoshop. Come on. But it does strike me that the business cases will be different. So you put in creative there, but of course the models is like, sure, get rid of that zit I had, right? But don't, change my expression or,
Or,
Right,
how tall I am, or
right.
So can you just
And that's not
explain-
really about creative, that isn't drawing a creative line.
Okay, I just want to say the models that I've talked to think that they are adding a lot of creativity in a lot of the different ways they do that, but that's the.
Right, but okay, maybe don't change my expression, but don't make me thinner? Is that really
Yeah, I
creative?
don't know, they talk about their exercise routines as part of what they add to the images.
Right, but is that creativity that they're adding? I mean,
I think it goes back to what's
I think
creativity.
it's presence.
Right, but can you just explain for the room why civil countries,
Right.
it's not hard for them to.
So basically there's sort of fundamental, differently oriented towards precedent.
Yeah.
In a civil law country. So they have a code, they interpret the code, and one judge's views don't necessarily tell you what's going to happen the next time. And so even if you did get a weird judge saying, oh yeah, no, now Photoshop is outlawed, that would not affect the main.
More flexibility.
Whereas, so we're a fairly justified, it seems to me, culture of distrust. Like, we would rather have a rule that we could interpret because otherwise it seems like it's open for abuse. And so we should be writing rules that enable us to distinguish between Photoshop and, Claude.
I was just going to say, we have some examples of this with past technologies. One that's coming to mind has to do with sound recordings that have been remastered.
Oh, yeah.
So when a record label releases today a remastered jazz recording from the 1960s, and the record label is supposed to explain to the Copyright Office what I did, I simply converted it from an analog to a digital format, they're going to say no new copyright. If I simply adjusted the volumes, maybe. If I did, and then you could come up with all sorts of magic words you have to say about equalization and all of these kinds of things, then the Copyright Office gets more likely to allow it. And I imagine, like Jessica's answer of practice-based, genre-based, medium-based norms developing, that at the end of a session on Pro Tools, it spits out a document with a bunch of words that says, here's the things that we use AI for, and here's the things Chris did, and same thing with Microsoft Word, and same thing for Photoshop.
I'm always a little worried, I generally feel strongly that we should let the different practice groups generate their own norms and rules, but I'm very sensitive to the fact that often in those groups, the stronger hands get to generate the rules, and so I'm wary of that. It's good that the model and these people are asking lawyers to help them negotiate these contracts, but in the end, the agencies are going to win this fight. I'm worried about time for this.
Yes. Well, please join me in thanking our distinguished guests here. And thank you to HOSD for helping put this together. Thank you all.